All right, let's dive right in. Today, we're going deep on one of the most powerful and frankly most debated articles in the Indian Constitution, Article 11. Think of it as the ultimate source code for Parliament's authority over who is and who is not an Indian citizen. So let's get into it.
So let's start with the big question, the one that frames this entire discussion. Who really has the final say on Indian citizenship? Is it baked into the Constitution itself? Do the courts decide? Or is it Parliament? As we're about to see, Article 11 points to one answer, and its power is, well, surprisingly absolute. To really wrap our heads around this, here's our game plan. First, we'll tackle what's called Parliament's plenary power. Then we'll see how that power was used to create the 1955 Citizenship Act. After that, we'll jump to the modern day with the CAA 2019 challenge. And finally, we'll look at the absolutely crucial role the Supreme Court plays in all of this.
Okay, so let's get down to the foundation of it all. Everything, and I mean everything, we're about to discuss flows directly from the immense power that Article 11 gives to Parliament.
Now, before we even read the article, you need to understand this term, plenary power. This isn't just a fancy legal phrase. In constitutional law, it means complete and total authority. It signals that this power is massive and isn't easily limited. This very idea is the beating heart of Article 1.
And here's the opening phrase is everything. Nothing in the foregoing provisions shall derogate. You know what that is? It's a constitutional override. It's basically saying that all those other rules about citizenship in Articles 5 through 10, well, they can't stand in the way of Parliament's power to make new laws.
So what this means is that Article 11 essentially hands Parliament a blank check on citizenship. It gives them, quote, unfettered power to decide on the whole shebang, how you get it, how you lose it, you name it. And this is the exact article that gave Parliament the green light to create our main citizenship law. So Parliament has this incredible power, but what did they do with it? Well, they didn't just sit on it, they acted. And the result was the massive, comprehensive Citizenship Act of 1955, which to this day is the cornerstone of our citizenship law. The 55 Act basically laid out 5 main roads to becoming a citizen. You have citizenship by birth, by descent, through registration, or through naturalization, and each one has its own set of rules. Oh, and there's also a special provision for folks in any new territories India might acquire. Now, the Act also lays out how you can lose citizenship, and it's pretty direct. Renunciation is simple, you just voluntarily give it up. Termination happens automatically if you become a citizen of another country, since India doesn't allow dual citizenship. And then there's deprivation, which is the most serious. That's when the government can actually cancel your citizenship for things like fraud or being disloyal to the Constitution. And that brings us right up to the present day, and to probably the most controversial use of this power we've seen. The Citizenship Amendment Act of 2019, or the CAA, is a huge modern test for Article 11, and it sparked a major constitutional debate.
So what did the CAA actually do? Well, it boils down to this. For most people, becoming a citizen through naturalization requires living in India for 12 years. The CAA carved out an exception for specific non-Muslim minority groups from Pakistan, Afghanistan, and Bangladesh, slashing that requirement down to just 5 years.
Now, the legal challenge to this law goes right to the heart of the Constitution. The petitioners are arguing that by basing the rules on religion and country of origin, the CAA violates the fundamental right to equality. The government, on the other hand, is defending it using a legal concept called reasonable classification, saying the law is a fair way to protect persecuted minorities. So where does this all stand today? Well, it's very much a live issue. We're talking over 200 petitions here, and the case is still pending before the Supreme Court. It's safe to say it's one of the most closely watched cases in India right now. And this brings us to the final and maybe the most important piece of the puzzle. If Parliament's power under Article 11 is so vast, so plenary, are there any limits at all? Is there any line it can't cross? Well, this is where the Supreme Court, the guardian of the Constitution, enters the picture. To understand how the court has traditionally seen this, we have to go back in time to a landmark 1961 case, Union of India versus Ghaus Muhammad. This is really the foundational judgment on just how far Article 11 goes. Now, pay close attention, because this is a 5-star point for any law student. The key takeaway from Ghaus Muhammad is that the Supreme Court said, yes, the power under Article 11 is plenary. In fact, it's so powerful that Parliament can even make citizenship laws that work backwards in time, retroactively. That's an incredible amount of authority. And just a year later, the court had another chance to weigh in with the case of Izhar Ahmad Khan versus the Union of India. This one was a direct challenge to the entire Citizenship Act of 1955.
And the court's decision was crystal clear. It upheld the whole 1955 Act, calling it a perfectly valid and comprehensive use of Parliament's power under Article 11. So these two cases together built a really strong foundation for Parliament's supremacy on citizenship.
And that is why the CAA petitions are such a massive deal. They are the ultimate test. It's the plenary power of Article 11 going head-to-head with the fundamental rights of equality and non-discrimination. How the court rules on this will set the precedent for a new era.
Okay, so let's do a quick recap. What are the absolute must-knows? First, Article 11 gives Parliament vast plenary power. Second, the 1955 Citizenship Act is how they've used that power. Third, the CAA 2019 is the biggest modern test of that power, and it's still being decided. And finally, it's the Supreme Court that gets to draw the ultimate line in the sand between that power and our fundamental rights.
Which leaves us with the million-dollar question, the very question the Supreme Court is wrestling with right now. Where is that line? How far can Parliament go when it defines who a citizen is before it starts to cross over into the fundamental rights guaranteed to every single person? The answer to that question will define what Indian citizenship means for generations to come.